Bail. Huh? All bails allowed. Okay. Yes, Madam Julie. Any interim? When? Give a date after 25th. Interim to continue. 52 allowed to be withdrawn. Dismissed or withdrawn. 38. Yes. When? 14. 14. In interim? Interim to continue. Yes. 1-3. Wait. Wait for some time. When the matter reaches. Yes. No CD? When?
This is so 22nd.
22nd and 22nd. Yes. 50. What is the matter about? What happened to Mr. Kotogi? An interim order? You know nothing. You will not adjourn like that. Yes. You are rejected.
Item number 1.
Yes. Please keep before the appropriate beds. Or 439 not necessary. Yes, Suli.
But earlier the Justice Saikya had rejected.
But 439.
439.
To the satisfaction of?
But he is involved in misappropriation of money.
81 days already. 82 days, considering the length of detention. To the satisfaction of? And the co-accused has been granted. Co-accused has been granted.
But then he was a coordinator.
Coordinator. 81 days, I think, sufficient for you.
Item
To
2.
the satisfaction of? Okay. CD, one. Whole truck with iron rod.
What I see is evidence are collected against this petitioner, but what evidence is not there? So CD will make it.
CD will, that's right.
So, 44 hours at the second.
40%.
3.
CD. Huh? That will this
24.
24.
No, John, 24 is a Sunday.
Yes.
21st.
21st. Where? Correct it. Correct in half of yours. Which your initial.
I think 62 of supplementary list.
We are giving an absolute bail for on the day one, and we are asking the police, where is the police report?
On
What is this? The Jacob Matthew, or what was the judgment?
Lordship is speaking about Article 62.
Yes, go to the FIR.
So the council is not there. If they are looking. The surgery was conducted twice, so the surgery again performed in another after within 15 days. One week of the surgery, one month after. Wrong 15.
Can an FIR be lost like this case be registered in view of Jacob Matthew?
Yes. Negligence of the doctor, there are guidelines.
Guidelines, Jacob Matthew. We'll know, we're not saying anything, but absolute. None appears, local let us not say the senior counsel's name is there. Absolute. Considering the nature of allegation as well as the dicta laid down in the Jacob Matthew versus so-and-so reported in so-and-so, is code of the view that the petitioner is entitled for privilege of pre-arrest bail accordingly granted, not interim, absolute.
63.
CD. You tortured like anything, this person. Be there for some time. This is not done. This is not done. This can, we know it. This is not a case for
18th of September.
18th of September. CD.
4. Motion AB.
CD. Therefore, we will see where you are apprehending. If Bablu and we want to know the reason from the case diary, not from you. CD. CD. You are at liberty to appear before the police, and police at liberty to arrest him. Write down.
20th of September.
Yes.
I think this year, I got here, 14th of September. No.
I think 5.
Yes, CD. Specifically named you. We'll see that. You have specifically named how you inflicted the injury, everything. How can you get it interim? We'll see the case there.
That is, let it come out on 18th of
18th.
September.
I think 6.
CD interim within 10 days.
CB on then later date, 25th of September.
20.
Item 7,
Hmm. I like crossing petition. Land dispute but serious injury, head, neck. Police will not arrest if this is a false evidence with the medical report. CD.
Yes, sir. Nagaon for.
We are very liberal in granting.
19th September.
Have the CD otherwise we may consider on the floor.
item 8,
Huh? What time being? We'll call for the case diary. Case diary. Huh? CD. When? Yes, 14.
item 9,
CD. Postmortem. 21.
item 10,
What is this? CD interim. That photographs are between you and that lady. LS. CD interim. Record your statement within 10 days. 20.
11,
Sometimes we allow and bail petition and make absolute without presence of the council.
I'm sorry, my lord, I just missed it out.
Yes. Passover. CD interim. When? 11. Yes.
12,
Mr. Nayar, is it necessary to record the name?
It is beneficial for my.
But now this is difficult because of this live streaming.
I'm sorry, Lord, I just, it was a calculation.
Yes, next.
My lord, FIR is page 8, I will consider. My name is not there in the FIR.
CD interim. Get your statement recorded.
item 64,
Considering the statement at paragraph 4. Considering the statement made at paragraph 4, this court of the view that the petitioner is entitled for interim protection.
so motion item 64,
Where is that? Now tell us one thing. Kindly come to page 36. Earlier you approached, you were specifically asked to appear before the court on 18-3. You did not appear there. You have not appeared. You sought an adjournment. 38.
I have got adjournment only.
You are not inclined to appear. Hereafter
I
also.
have find it. I have appeared. Otherwise, I will send you.
Okay, it is stated by the learned counsel for the petitioner that The affidavit in terms of order dated 1/9/2023 has been filed. However, same is not on record. Accordingly, register to verify the same and very no way out. We passed this order on first. You file your affidavit yesterday.
Last time was this opening. I don't also pass your account and then next another to. You opening
Okay, we'll take it up later on call. You ought to have made a mention that I have filed a affidavit, call for it. How can you pass an order? You are not sincere at all.
I will be.
Those are not our concern. All the this is, we do not appreciate this.
Bail hearing BA, I think the 16th.
Third seated. Huh? Why depositions are called? What is this? None appears for the petition on call list next week.
17,
Yes, where is the FIR? Yes, there is there. How many days? What is the allegation? At two.
18,
Yes. CD receipt, Buru. How many days? What is the allegation? What is the allegation? Where is the FIR? Huh? Page? You are accused. CD. 22.
19,
CD is received, Buru. Not received. CD is not there. How many days? When? 19. Next week. Okay. Give a date. 15.
20,
Yes. Where is the FIR? How many days? Be there for some time. When, Buru? 20 cases they received. Yes, what is his involvement?
Now, he used to know the parties, those moments to use to spend by the other parties. Now, on the basis of CBR, look to do the
But you are the instigate because if there is a market, available market to sell, that thing will be more. May seems petty offense, but you people made the life of the citizens hell. Let us start rejecting this criticism. Is the purchaser.
Yes, connection with the mother. No, I am not a articles. Synonym to you.
Let me see the CD. What are the offenses stated? Oh. Mohibul Haq. To the satisfaction of 40 days. CGM Kamrup Metro. 50,000.
21.
Yes. Where is the affair?
Basic education, the document, connection is the my relationship with someone else. That's the cause of first return. That's because we were connection. Because of 60 days, I'm already 53 days in time. Two kinds of special. There are allegations that we must have extra message.
To the satisfaction of
Yes,
length of detention. No? CGM Kamrup.
22.
Base. Yes. Accident.
Normally, my the problem is everybody has obviously recovered.
How many days?
44 days. 44 days. We can,
After a week.
what is the latest? Because the danger is located in up to
How will you find the body? You are not.
28
No. See, apparently seems three things went. There is no intention, nothing. They went to River Brahmaputra. One was
Yes, even what is the one not the 8 has been recorded.
what is
They
the
have also they have not directly indicated because there is no eyewitness.
no eyewitness. They went, they are friends. There is no allegation that there is any enmity. Why should they go together? Had it been a case that okay, there was a fighting, they called him, then they went with him and thereafter he missing. Nothing is there. The three friends went to River Brahmaputra, one was missing. 44 days. 44 days. Let him go. Okay, objection. I do not think this is a case of 302 or something.
Yes, may not be.
Body difficult. How many 42 days you are not 44 days body not recovered. Difficult from River Brahmaputra. Kamrup, Aminda.
23.
Yes.
If there is.
Who are they? That Borpeta Road. Ah,
Prime Minister is also different.
whether prime accused is granted bail or not, we do not know. We'll see that the thing. How many days? Who was the owner of, there was a Scorpio, black Scorpio, is not it? This is the case. What is his name? Your name is?
There, Azimuddin Ahmed, then one Fataka Salim, and one Bidar Hussain.
Dilbar, Akas and Azim. What is the allegation against them?
Allegation against them was.
Asan was a driver of the other vehicle. He purchased it. You robbed it. Isn't that it?
No, one Mr. Mane was it, he robbed it.
He robbed
Then
it.
was it, he said that he, this quantity, because we cannot pass the, Sridampur gate. So, they have, contacted this to party.
Okay.
And whether you can, I'm not sorry, and can you hide it, can you find something where you can hide it? So they have arranged the one room, so it was hiding.
How many days? Objection is, I have a standard line. Serious and vehement objection. This was also like similarly situated. But they have not come, na? You have not been able to arrest those persons who blocked the vehicle.
They are yet to, this is why I am objecting.
Ah,
But they are, their connection is there. It's
ah.
not that they are nowhere, they are connected. But the person who wrote is a Muslim.
But you arrest them and bring it up and file a charge sheet on the basis of their statements and all.
24.
CGM Borpeta. This is item number 16 is gone. It's like river Brahmaputra. You cannot come back. Yes, next. Make a mention after the list is over at 1. Yes.
Item number 24. We have received the case, then after some time.
See, he wants something. He is not seeking an adjournment for a week. He is saying that he will go through the CD after 6 days.
Supplementary item number 66.
Yesterday matter was directed to further photos of the medical. It was getting here.
Anything?
Hello, I have contacted him on the day or yesterday. So he has informed me that one report has been said to be deputy director of the emergency.
Okay.
And notice, he has already informed me notice that near about in the month of July, he was produced report as well. And he came down with it.
Okay.
And he was secretary between the legal police. Therefore, he was referred to Greenfield. He remained there for 2 months. After that, he has recovered, so he has again number 20. That is what I have been informed, but what is there in the report that I have not been able to do.
Let's just verify any report from Superintendent Visual or.
Finally, go to the across border to the border.
Okay. You just have it, otherwise we are granting him bail for a limited period for treatment. 2 months. But we'll see whether report has come or not.
That's what I think informed.
So telephonic information, and if record is there, we'll verify, will take it up at 2. Exactly. Okay. If you verify.
Day nearing 25.
কোন কোন লোক? Yes.
Next, learn living continuously. AI is out of perform education. Kind of system next.
What is the material on record?
As per the practical knowledge,
No.
the EPS positive test for formula for
No, no. The allegation is that he বিষাক্ত দ্রব্য সেবন কৰি আত্মহত্যা কৰে। But anything that what was the situation whether he did
what that knowledge about the suicide note also finding the suicide note.
okay, we are adjourning it. Okay. Though the case that is received, matter stands adjourned on the prayer of the learned counsel for the petitioner and be listed on Monday may not be possible Tuesday. The case that will be written.
26.
Yes. Yes.
26 na speaking of the city.
Not receive. We are on interim. When?
23 1 January.
Goswami, when to fix?
Paying for another 18 months.
18th of September. Okay. 18th of September. Interim to continue.
27.
27 also on the city.
Any interim?
They are interim.
Yes. On.
27, 26.
28.
28 also मतलब similar kind of city. They are interim.
When? This is from
26 now.
26. Interim to continue.
29.
89 also मतलब they are interim मतलब.
Yes, when?
27.
27. Interim to continue.
30.
CD received.
City not receiving.
When? Interim is there.
30 now.
30. Interim to continue.
31.
City receiving.
Yes, where is the affair? Yes, what is the material?
If this serious level and their statement is also not clear. Their telephone that was found in the
Because according to allegation, what is your name? Salam Ali, Ali Akbar, and Surman Ali. Allegation is that they chased him, he fled away, and thereafter his dead body was found.
That manner, the supporting witnesses also during at that time they around the house of the deceased man. But after 15 days, when his body was found, it is very decomposed state. And therefore, the PM also is not
I
very
think-
accurate.
Any earlier bail application was filed?
And furthermore, my their statement is also not regarding the intent, they are looking. So, my I pray that it is also up to date. So I pray that our city be updated. So it is still,
Why CTB upgrade? You reject it.
we have 12, 4 is the last day, madam. That is all. It is absolutely updated. The conservation and one minus on 16.
What is the cause of action in a criminal case, a death to murder?
I, the brother, when the brother of the petition number 2 was found in the, he was not a matter. Then on suspect, found the particular distance. The one brother of the Samadhan brought the affair on suspected that they.
Whether after interim have you gone to the police to record a statement?
I was in all the.
Okay, though it is stated by the petitioner that after passing of an interim order by this court on 26/4/2023, the petitioner got their statement recorded under section 160 and CRPC. However, the learned additional public prosecutor submits that CD is not up to date. Accordingly, he prays for an adjournment. Prayer is allowed. List this matter.
On 28,
28,
September 28.
28/9/2022. For production of an updated case diary. The case diary be returned back and the petitioner shall be at liberty to once again appear before the IO to record their statement. Go and record this. Maybe you go there, but your interim order pass are less than.
Item 32,
Yes.
I think we have a city of this in my own journey.
Okay. Should it not
My
be-
next anything is sensitive, but I have no instruction regarding that.
That's good.
33,
Yes. Base, what is the age?
My age is 34. We were earlier having a relationship. She was subsequently married off. Even after marriage, we continued having an affair, and then their family found out this affair was gone.
Subsequently, she got
She
married.
was married off by her family, another person. But she was initially in a relationship with me.
What is the affair? What is the affair?
Please say another.
Oh, that case. Okay. Necessary of allegation. Considering the necessary of allegation, material available on record, and also considering the fact that petitioner has duly cooperated with the investigating authority during the authority. This is there.
35,
Yes, where is the affair?
Surfacing material
Not
is
necessary.
not a case of minor anticipated repayment.
This is not a, everybody is, anybody is coming for anticipated rebate, rejected. Peruse the CD, sufficient incriminating materials have been collected against the petitioner. Petitioners, therefore, in the considered opinion of this court, this is not a fit case where the privilege of pre-arrest bail should be granted to the petitioner. Accordingly, the present bail petition application for pre-arrest bail stands rejected. Any interim order earlier? No. Rejected.
36.
Madam, here is surface.
Search sheet being,
After traffic,
after search sheet, we have come before the court.
Nothing can be put there by a state here. You are also, I'm not feeling that, there is no additional against.
But we need to see the something. Where is the FR?
After state. The performance taken by the finance.
Any interim protection?
And now looking at anything that page 60. That I upload into the runner, my application was rejected. There is some observation regarding 164 statement, that I don't know, but I have got that from this order. Document last line, page 60. And this is incident of 2014 versus December. And I have ensured, I have filed one additional affidavit to one record.
What is your name?
My name is Abdul Ahadul Islam.
Elias Ahadullah. Syria Salary.
Document kindly see that additional affidavit, page 22. Page 21 is one 24 proceeding. We have filed against another against the husband of the that is different person.
What is the additional affidavit?
Additional largely case 21.
This is her statement.
Prior to their notice, prior to the present incident, notice filed 125 proceeding against notice 1 Abdul Khair. Notice now kindly see a statement in that page 22. Working with government employee is picture by profession. And immediately during my matrimonial dispute, he was asked to attend the picture. Document is paragraph 4. He could not settle it, so therefore he was leaving. This is government employee. It will not be from page 9 is identified.
Registry to call the case diary of.
It is already potentially.
Yeah.
150% is there.
Yeah. Maybe wrong, maybe false, maybe, but the fact that she was recovered from Haryana,
He lost with another person, that you lost it when you think that in
Raju and something like that.
in testimonial proceeding of this, there was a demotional Raju. Whether he is desirable or not, because he is a present petitioner, is a government employee, he was attending his school working. Everything is there, he can produce before the trial court. And this kind of putting him behind the bar, that will also prepared in the service career. So
Ms. Bora, what you say? Otherwise, at this stage, his presence is not, his detention is not required as such. Someone, prepare.
Now, yes, only a thing that my people was rejected on the ground that I was not cooperated in. I was not named in the affair. If I have not cooperated, I was attending my school regularly. He should have arrested me. Personally, anything page 17 last year.
Page 70 now.
This petition. Last year. It appears that the accused person did not cooperate, I was living in this case. I was not named in the affair. So how I will know that the case is standing against me? I could have filed bail application earlier. At that point of time, if I could have any knowledge about that. Or I could have arrested me because I was attending school, my school regularly.
Okay, look into and pass the order. We'll see it. Okay, we'll consider it. We'll consider. We'll see entire things case there and we'll see it.
And the additional appeal of
Yes, we'll see.
all right.
37.
Huh?
May.
Alamat Masu.
May is your logic.
Yes.
After some.
39.
Yes, Mr. Chaudhary.
Here in the system,
Jagat Jivan Deka. What has he done?
someone name is not mentioned in the FIR, madam.
Hmm.
In the inquiry report, preliminary inquiry report, finally inquiry report, this name was not mentioned.
Hmm.
But one thing is happened that after getting the agreement, my love,
Hmm.
the honorable court has directed the appeal because this is what I know, my love. And so they can, my wife, but I am in Chennai.
That is my love. Yes. Otherwise, my love, I yes,
Nothing.
unnecessarily keep it in my head, man. I think, my love. But why he is apprehending, my love, that statement might be required.
Why is it apprehension?
Apprehension, my love, is searching, my love.
They are saying, we are not even searching him.
Now he has come.
I said appeal report.
When can you appear before them? Heard Mr. NNB Chaudhary, Learned Counsel for the Petitioner, also heard Mr. Goswami, Learned Edition Public Prosecutor. This is an application under censorship. Case diary produced is perused. considering the no specific allegation is discernible regarding involvement of the present petitioner in the commission of the alleged offense. However, it is seen that the petitioner has not appeared before the investigating authority to record his statement pursuant to interim order passed by this court on 28/7/23. 28/7/23. Mr. Chaudhary, learned counsel for the petitioner, submits that his wife is seriously suffering and her treatment is going on at Apollo Hospital, Chennai.
Yes.
Apollo Chennai in the nephrology department, and therefore he could not appear, and he will appear the moment he returns back from Chennai after the treatment of his wife. When can you appear? Tell us. Okay. Mr. NNB Chaudhary, on instruction from his client, further submits that within 15 days, within 20 days, he can appear before the IO to get his statement recorded under section 161 charges. Considering such statement and the material available on record, this court is of the opinion that no custodial detention of the petitioner shall be required for the investigation of for further investigation of this case. Accordingly, the interim order passed earlier is made absolute, subject to, however, the condition that the petitioner shall appear before the IO within a period of 20 days from today. But you will have to file an IA to correct order dated 28/7/23. This is a major mistake is there in this order. That mistake we cannot accept. You have to file an application. No, we cannot accept that.
I think 40.
Yes, series there.
My city is from the city related marriage. Who is the main person to attend the police person?
Wait for some time. We will see.
41.
We'll call this at after list is over or have to go through.
43.
Where is the affair? Affair? I think this is the fourth case today from morning.
This
What
is
is happening? This is the fourth case.
it was 60.
A young boy. I think I have in the motion.
Also, there is another student also in Panda. Eight student, 9 student. Same thing in the suicide note. Very important.
No, suicide is, you may say that is the weakness of him, but the way you are doing,
How is your tendency?
not only you, we are not saying in the other three cases also.
You are not a suicide, maybe what kind of say that? Are you just telling a suicide? But the same or suicide note as well as the way of say that.
And madam, your people are also involved with these people. That's why even there is no interim order, nobody is being arrested. Specific allegation is there. And why should we not ask for an expand this and ask for a CBI inquiry? Let us see how this money lender is nexus with the police. Let there be an inquiry.
They are doing this work. There was also positive, but where is the kind of situation? And they also one died.
See where it has gone beyond control.
People are now becoming a class 8 student, 9 student for education. Then madam, we just must be safe and pay. Signature in one day, signature or something other day signature.
And that will be case of trial. Where is that?
Pay and pay no problem. Pay no problem. Pay and pay as a name, pay 20 English. Even to the wife might have paid 21. You think the man might have 2 lakh rupees? You know, our neighbor might have 2 lakh rupees of income. Pay 21.
Rejected.
I was very might have. So,
I cannot.
everybody is concerned about that.
Rejected.
Oh,
And madam, we will take action. This is the part I'm looking into. We will take action. The message should go and call public prosecutor at 2 out of this. Will not spare anybody. And these are a nexus. This is a gang, and these police are part of it. With the help, with the support of police, they are doing this. This no interim was granted. Police is so helpless that this person will not be arrested. Now they will not arrest, they will file a charge sheet, say that he is absconder. He will come back to us. We will see what is the necessity to arrest him. Because already charge sheet is filed. This is the nexus. We will not spare.
CB is there, they have sent for FSL, but FSL report is not available.
Where is the FI?
Page 10 is also.
Hmm.
But what is doing the FSL report? And this particular town in some of you. So Mizara is fantastic.
Okay. FSL is not there.
No, no.
When?
What is, FSL, what is, 22, what is 22,
Okay. Learned additional public prosecutor press foreign is granted time till 22nd of September 2023 for production of FSL report along with the case diary and postmortem.
Sitting is there.
And the
Can be there.
FSL
45.
yes.
Application.
Mm,
Page number 30. Primarily, education is there. One of the banks starts my law. We have idea of my law done some. Providence collected 7,64,000 rupees against state deposit matter. This may be given to one.
just a minute. Please before any other bench without.
46.
So that. Only the simulations and how you feel it is what- But the flow of the is from that 60. May I submit it? 46. Anything taken up at CPM?
This is
Now, I'm trying to solve it.
uh, if I cannot take up, I cannot take up. You make a mention before. What to do? Okay, at least before any other bench without me. The learned counsel for the petition must submit that there is already an interim order and that needs to be extended. So that matter may be directed to be listed today itself before any other bench. Okay, in view of such submission, court must to place the matter before the registry for doing the needful. Send it, just type it, sign it.
Item 47.
Can be taken up at CPM.
Item 48.
It was possible that you have to fix it.
Yes, where is the bill 438 or 439? 439. This is 438. Then you want that? Huh? Earlier, quick use was granted by 438 or 439. If you want that, 439, we can ask you to. First. Where is the FIR? Case diary called for was not received. However, case diary called for is not received. However, you are Mr. Huh? So and so, learned counsel for the petitioner submits that the prime accused in the case, namely Kabir Ahmed, has already been granted in interim anticipatory bail by this court in AB 287/2023 on 30/8/2023. And therefore, he praised that being situated in a better position, he is also entitled for such privilege, in as much as main allegation is against the accused number one. Considered the FIR as well as the order dated 30/8/2023 passed by this court in AB 2878 of 2023. And this court is of the view that the petitioner is also entitled for interim anticipatory bail. Accordingly, Swenso allowed place this matter on 25/9/2023 along with AB 2878/2023. This is on all the. You appear in the meantime. The following conditions.
49.
Yes. Is
one particular case out of 14 accused, and you will say it is at case serial number 12. Unit here.
just a minute. A series there. Puro? Okay, just let me go through that. This is anticipatory bail. No CD is required. Specific allegation.
But my name is not here. Only at case 14, my kind.
Yes.
Mohammed, but his father's name or his name is another name. And his reason for the difference. My relative. Support button.
Then you are not the man. People, police will not arrest you. Where is the apprehension?
Because his name is here. He has been named Balot, but to be fairly clear, go to pay in the state in the services. And then also the one arrested accused person. You was assaulted by several parties.
Right, so that
Huh,
was specific.
if assaulted by, he was tied in the residence of somebody, Sohrai Munda, and these people were having, according to the arms and all. And yeah, subsequently that person died. So this man is specifically named in the FIR. These are known people, they know each other. Maybe he might have some relation with this Munda's wife or sister. But will it permit to kill him like this? They know each other, all are related in the next village, from the next village. Rejected.
Item 50,
Yes.
If there is no.
Yes, is there in opposition? Over.
90.
90.
item 51,
Yes.
Already repeat. Fire even case like this.
Sheet is there, bro.
If there is not, it's the 154 settlement. It will report it before you. What if, the allegation is under 279, 325, 324, 307, 509 versus. But if, this is a case of less likely person, nothing else. Complainant is a police personnel worker. The whole FIR will be framed. Prime accused who has been arrested, he was granted bail, and the court below has made an observation that 307 does not attract logic. The forwarding report of the prime accused has been annexed. One who was billion rider. Case number 4 lawsuit, relevant arise, that 4 lawsuit. This is pure case of 279 lawsuit. And the prime accused who has been arrested was left behind. One was false lawsuit on the death of the other one is level.
Now he is apparently injured.
He is a driver lawsuit. He and the complainant herself stated in the FIR clearly that she was in a road, concrete road. And that time the accident took place and the driver, he was an accident lawsuit and the one who was sitting pillion rider, he was caught rider.
What is your name?
He may be lawsuit.
No, no, not your name.
Dinazul Islam. Dinazul Islam.
He was driving the motorcycle.
He was driving the motorbike. The whole allegation is against the
Hmm.
Ikramul Haq.
And within 7 days, he will be allowed to appeal.
7 days. 10 days you appear. Did he return back?
Three.
Fifty-one. Granted.
Hmm?
Granted.
Yes.
The phototype application is started in manner also. And we will do a 50% of this now also. And, you can show what the rate of the,
So any case can go to?
So, let us paper and then.
What is the next date?
Next process. Today is the next step.
Huh?
8, 9, today is the next step.
What is the order?
असे विनायक बरोबर ते voting होते. त्यासाठी आपण सेंट्रेट कटिंग होते. तो 2 8 होते. Next to 8, 9.
8, 9 is, what is the 2 days date?
So it is 2 8 होते.
The scan, the order 24/8 scan copies will call. That is not there, so we'll wait for some time. Huh? Office note dated 2/9/2023. In view, reflects that scan copies of the record called by this court under its order dated 24/8/2023 is not received. The registry to forthwith issue reminder in as much as the present matter involves a liberty of a citizen. List on. Divided 20.
No,
54.
54 is very not.
Is there in order? Give a short date.
School teacher.
Understand, but what have you done is not a behavior of a school teacher. Huh? We have taken one part, we have no problem. That both of you going to hotel and all, no problem. But threatening to viral the private photos, we have, yes, Mr. Bola, it's from nearby, I think Nurmat or something like that. Not next Friday, next Tuesday, Wednesday. Have it next Tuesday. Have it, call. You can, huh? 13. Let us see how.
I think 67 supplementary list.
They let us know.
The last, I was forming those.
It's for.
Waited. Okay. The postmortem report called for is not received. Accordingly, matter stands and be listed on 22nd for production of the postmortem report. Interim order for service. Keep it. Finding nothing.
Academic items, number 24. 24.
Yes, what happened to Muthu Krishnan? Oh, that man. It is there.
Garden versus Dam versus. So, my look, you was exam and what is the question was recorded with the help of a interpreter. And then what is the
She was sleeping in the platform with another lady. She was picked up by this security guard. Considering the statement of the where is the material given? Also consider the statement of the victim girl who is aged about 25 years, who has not implicated the present person. In view of the aforesaid, allowed speedy return. People are busy with not their own business. Sorry, 90 days. Thank you. Hello. To the satisfaction of CGM. Unnecessary, this man was arrested.
Item 37.
It's a case for quashing now. I could understand. But this is not, it's a case of quashing now. On another statement. Yes.
Item 37.
Not at all 376. Maybe there may be something, but this is not a case of 376. Yes, she refused to get medically examined. Yes, item.
37.
None appears for the petitioner on call when for the second time when the matter is called. Accordingly, list after 3 weeks. Any case there is there? This is fixed at 2 p.m. No, this is not true. We are calling
37.
37. That's why we are fixing after any case there is there. So return back the case there. Or any materials are there. Burua. 36. 37. What are the materials? Okay, why should we keep the schedule in absence? We'll hear it. We'll hear it at 2. At 2.
Item 40.
Maybe permanent. Not online. Is the item number? 14.
Landing item 40.
Any case diary? So take it to. Go through it, will, if any absent will go in.
41. 41.
Case diary is there, 41? Okay, approved.
46.
Okay, once again, we are giving a sunset.
For orders item number 55.
Yes, Mandal, what is this? Why this matter is listed? What is this matter about? Tell us. What is this IA? Cancellation of value on sometime. Okay, when? Not next week. After Puja. Yes. After Puja. Okay, under prayer of Mr. Mandal and the council for the petitioner, matter stands adjourned and be listed. Give a date.
Number 228.
Mr. Goswami is present representing respondent number 228. Give a date,
9th of October.
9th of October.
So Washman
Also
item
hard to PP notice.
56.
Yes,
Document renewal made. Timing
who is your senior?
as this one.
Friday, no time being. This is Arunachal.
Yeah.
What is the case? Any cognizable offenses made out? Let them take action under the special act. Private remains efficient. Where is the case for proceeding? Proceeding of what has been stated?
That, in fact,
You are representing whom?
the comment number 2,
Respondent number 2 is
the first informant.
first informant. Now case is this, that this person has occupied a government land and constructed a building. He has been given many notices. He has not demolished this house, therefore FIR. Where is the cognizable criminal offense? Tell us. We'll pause this. What to do? Under prayer of the learned counsel for the petitioner, release this matter. No case. You don't have any case. Release this matter. When? Oh, you will adjourn and get it day after tomorrow, after vacation. FIR is registered under what?
188 and the 41 of the Arunachal Pradesh Public Remand Project. And in that we have a case.
We'll definitely give you. You take the land, demolish, do everything. What is the purpose of lodging this FIR? After Puja. That is the difficulty. There is an interim order. Yes. 6th of November. Date to be fixed by registry. Interim order passed earlier.
59.
Yes, what is this? What is under challenge in this petition?
And in our page of the code, I think, that I'm going to be submitted that today. Sometime when I'm going to submit, then I'm going to expecting by the comment, again, reinvestigation, other investigation was directed.
Then
After further investigation, again, the, did not find any materials that you have to person, so again, they submitted the final report.
Hmm.
Again, then, final report, government in the, again, one for the petition.
Mhm.
Now, the forest petition, the court rejected the final, second final report,
Hmm.
and then directed to register a plaintiff and procedure.
what were those materials?
Then probably the that there is no order that we copy to, that is the order of taking copy.
Page 44.
That is our ground without subscription and assigning any reason that after 2 times my lord, family will say, on the other hand, the 15 my lord was involved in 10 case of the daily bridge. Remember last time we had 10 case, particular case 299 was 40 miles. Why something fell of the daily bridge, someone abandoned daily bridge, it fell down on him and he was injured and got doing the exercise.
Hmm.
And only to change that act of the 15 mile that the informant through the brother of the 16 mile of the other member for the execution and get some of the false statement. And that's he gets acceptable to the subsidiary plan. That's actually also one of the subsidiary. So, because after this, why is it that justification planning for subsidiary and they are asking for
Conclude this, Bhattacharya.
yes,
Manoj, in this case, there are statements for PW 1 and 2. From their statement, it revealed that at least at that point of time, while the victim was injured, he was alive for some moment.
Hmm.
And before them, before witnesses, he stated that these 80 persons are involved in injuring him.
Before whom?
Before this is the PW 1 and PW 2. The statement of PW 1.
Okay, we'll hear it some other day.
Then I just like to tell you.
That is not by authority, not the private person. For the director of the municipal authority, he knows that the training. Why something that of the training is a part of the training still on to the 15 and then.
What is the basis of, Mr. Bhattacharya, what is the basis of initiating that proceeding? Because the investigating authority filed twice final report saying that there are no cases.
Regarding that,
You show us that what is the material available before the magistrate to accept and proceed that no, this investigation, the case is made out. First, there was a final report, court says reinvestigate, reinvestigation was done. Then again, final report. What are those materials? Please pinpoint us, we will go through it. Now we'll hear first, who are you? Okay, we'll hear you. First, we'll hear. What is the offenses cognizance taken? What the postmortem report says? Who was the eyewitness to implicate them? Then no, we'll hear you, not today. It's not a case for Friday, meant for Friday.
One thing is also vital regarding their stated that regarding one another case when seen who is the present victim he got injured. Now that case also has to be looked into when that FIR was blocked. Because probably earlier I have gone for that FIR was lost after 2 months of that incident. That is also one of the vital aspects.
Okay, we'll see. We'll see. We have not taken any view. We'll see whether police is correct or magistrate is correct, but not to this. Just point out those. You have some mark, some flag mark. But my point is, what are the material on the basis of which, even after filing of two final reports, court has proceeded. Number one. Number two, what are the reasons and what are the evidences before police on the basis of which police came to a conclusion, investigating officer came to a conclusion that no case is made out. Just point out this from the record. We will hear it, when? 2-8. You go through it, Bothakot, and just mark it. 28th of September, as agreed to by the learned council. You can also go through the record. Both all you go through it and mark it.
For admission, item number 13.
Yes, some adjournment was sought for. What is the method? This is for enhancement or reduction? Enhancement. Husband's salary was around 11,000. 11,000 and 3,000 to you and 2,000 to his children. 5,000. Now court has thought that now another 5. What is remaining is minus 7,000. 7,000 court has divided between the old mother and him. What is the wrong on that? There are 4 people. The person himself, his old ailing mother, his wife, and his children. Total 4 people. 11,000 is amount. His income. Some okay, 10,000. So divided by 4 is 2.
Now we see something else. Now we have come to know yesterday. Already married to somebody else. And during subsistence of that marriage, he married her. So we want to try and appreciate.
Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned. So according to you, the respondent, the wife got married.
She is married earlier. And without divorcing,
Okay.
she again contacted marriage with you.
Okay, but can we decide all those in this petition? That can we decide? Admittedly, 11,000 divided by 4, you are getting more. You are getting,
10,000 was
you are the lady is getting out of 11,000, 3 plus 2, 5,000, and remaining mother and the husband. We do not find any illegality in this case. Hope we will be satisfied. On what we are the learned counsel for the petitioner, the president says, are you paying? Yes.
at the engine of
What is the interim?
and the proceeding has been stayed apart from the payment that you.
Okay. Interim order pass earlier shall continue. Subject to continuous payment of the awarded amount. After puja. November. Into.
Time being Postman matter 57.
Adjournment. When will you be ready? Tell us. Give a date. Next week, give a date. 20. List this matter in the order column on 20. Tuesday may be difficult, no? Tuesday is difficult. So many matters. Let it be on Wednesday. When 20.
Oh, the 20th will be a different, because that is on 19.
19?
19.
Have a,
26 of the.
we are not taking so much time deciding matters and you are taking so much time in deciding dates. 27th. In the hearing column.
Then we giving our negative orders for disposal of that matter.
We will hear it. By first half, we'll finish all the matters and second half, we will hear the hearing matters. Date to keep. Oh, Wednesday, no problem. We'll finish by one everything. Then we'll hear in the second half.
145 proceedings. How much time is it?
We'll hear it.
For admission item 14.
Yes, CBI, CBI.
CBI has filed a written statement, my lord. There are two paragraphs which I found.
See, tell me, the matter is pending since when?
In 2000.
1985.
CBI was entrusted to investigate the case on 99 working.
Mm.
We filed our charge sheet on 2000.
2000. Now we are in,
File working.
we are in,
Very free.
And what-
Because of the fact that he upon that working. In 2003, the moment the evidence.
okay, suppose we assure that he will be present on each and every day. Then how many years will you take to conclude the trial?
That cannot be taken because I don't.
How many witnesses?
My lord, there are 51 witnesses. My lord,
So if
in the written
51
statement-
witnesses are there, admittedly record was also lost. Record reconciled
Record was was lost from the court.
whatsoever. I am not blaming CBI.
Yes, sir.
The fact remains that the original incident or affair was lost in the year 1985, something like that,
1994.
1994. Then CBI took over 2000, 99. Search sheet file
2000.
2000. Now he was absconding. According to him, he became a sannyasi. Okay, okay. Let us assume everything to be correct. Your case, their case, he became a sannyasi. Now, no case proceeded. So he thought that, okay, what will happen will happen. He tried to have a connection with God. So he was there. Now proceeded according to you because he was trying to connect with the God. The proceeding delayed. Now when he comes and says, no, I will remain present in the proceeding. In the meantime, record is missing. And till date, no record is, file is not reconstituted. And there are 51 witnesses. Now, why should this man be inside? Either he give an assurance, or we are giving a last chance that he will appear. You reconcile your file within a period. Thereafter, he will also give a local address. Is it possible?
Yes, sir.
Local address?
That he was responded because of the fact that Supreme Court has canceled his bail. What is the fact of it?
So Supreme Court has cancelled his bail on what ground? During when at what stage?
He will file.
We can give it. Will it mean that Supreme Court has gone? Then what will happen to? Can a proceeding continue like this? Then we'll have to give an higher authority to investigate.
Investigation has already been completed.
Completed. Now the file is missing. You have not been able to reconcile. Now tell us what is the law. Can a person be put behind bar during trial in a backdrop or background fact that file has not been reconstituted and there are 51 witnesses?
Lordship, may I pray to Lordship to kindly direct the court as well as CBI to reconstitute the file.
Reconstitute, even in other cases, court has said that it's a right, Article 21, recent judgment, all in these cases of even unlawful activities, prevention act. What is the judgment? Even Supreme Court says that, okay, there may be bar, but constitutional right cannot be wiped out by this bar under the act.
That is that was the responded. And conduct of the is very bad. That is
What about the conduct of the, okay, okay, so since he is absconding, you have not reconstructed the file.
Constructing it, Lord. Because on the basis of the document.
So do you suggest that till you construct, he should be inside the jail? We'll record that. When the file was lost, when the file was lost.
That was not, it cannot be said. When the file was lost, you cannot say because
Hmm.
the record is not available.
Record is not available since when?
On 23rd was it, when the accused was produced after his arrest,
Uh.
then only the learned specialist came to know that record.
Now, how you propose, how the court proposes?
Court is saying that by the order of it, he was directed to construct the file. He was to be on the way to construct the block. Within 1 month or 2 months, we will be able to.
So why should the person be inside for 1 month or 2 months?
My lord, the third paragraph says that in 22nd 9,000, my lord, is personal belonging and all the original case records were stolen.
That is different notice. That is a different chapter. That is the case diary and the document. Case record is with the court. That cannot be with the.
No, I'm not understanding. There is no case record as on date. Admitted position?
Right.
There is no case record on the as on today. He is behind bar since when?
22nd of last year. Like,
So
he was
22nd,
arrested on 22nd.
suppose he was arrested on 22nd. 22nd of
November, I think. if I'm not-
22nd of November 2022, he was arrested and produced. Now let us assume that on that date you came to learn that no file is there, file is missing. Okay. Now from last year till now to 1 year, he is behind the bar without any trial.
He was not behind the bar. He was outside.
Hmm.
He was in his delay. On 22nd, he was arrested. For 1 year, I think he's behind the bar.
Now tell us, prior to 22nd, when you learned that case record is lost, how the matter proceeded?
By preparing supplementary.
No, prior to that,
Prior to that, it was there, no, it was.
no date.
No, no, that cannot be ascertained, because the fact is that.
Therefore, if you cannot ascertain, accused, where will he come and appear? In which case?
Prosecuting the case where he.
With our limited knowledge, what we know is that a date is fixed in a case for appearance of an accused.
He appeared,
He appeared.
He said the time he is necessary examine.
She is examined.
Yes. After
Okay,
that,
tell me the dates.
yes.
Tell me the dates. Let us understand.
I think that
So suppose date A, he appeared. Date 2, he appeared. Date 3, he appeared. From date 4, he was absent. What happened in the record?
warrant was issued,
Warrant were issued when?
that those days were.
Why then? Suppose from which, if record is not there, it was not placed before the court.
Because it's the duty of the court. The court.
So why this person should suffer?
Understand what it is. He was not there till 2022.
No, he is not there. We will put him behind bar till you reconstruct. No problem on that. Tell me when the matter was last fixed.
Last.
On what basis you have produced before the
On
court?
the strength of the warrant of arrest.
Warrant issued in which file?
If. Yes, what it is. Here is the basis of this 96.
Okay, show us the record.
This is the case. Originally, this is the case. What you must.
Originally, this is the case. What we understand is, suppose a search is filed, trial begins. those who are on bail or not on bail, you either issue summon or issue warrant. Bailable, non-bailable, if someone who is not appear, you will issue a non-bailable warrant. Non-bailable warrant was issued because he did not appear, or he appeared 2-3 days, then he stopped. You issued a non-bailable warrant. He was not appearing. There must be some orders. Where are those? From which date till till his arrest? What are the proceedings? Tell us.
All the records will be to the decision.
So, if there is no record, how can you blame him that he might have come and said that there is no date?
His counsel was probably there.
Maybe council is probably there. What the council will do?
To enter in the court.
No, suppose
Diary not to.
suppose he is present. Suppose he is present. Assuming for a moment he is present. He will file Hazira where? In which case?
This case was it.
Where is that record?
Record is not there because.
From which date? You have no answer. And you have no answer, but you are saying he was an absconder, so he should be behind. But till we reconstruct the file, this is not acceptable to this court. We'll record everything.
I need to, my lecture, security inquiry conducted. And because how can a case record be?
You conduct your inquiry, this is you are CBI, you are highest authority. You
No,
conduct
we are
how the record was missing.
Record should be-
This is not the way a person, he's having a right of fair trial and right under Article 21.
I submit it to you. Yes, I need to-
Okay, madam, tell us the relevant orders and documents.
Well,
And
the custody was effect from again 28th of September 2020. That was the date when he was working, and since then he is trying to
what happened before that?
because of this.
To bring him, there must be an order.
My lord, may I read this order? How it is written, my lord, this is all.
Where is that page? Page.
Page 43, my lord, of the application. Starts with the word, original case record should not be placed out, and the supplementary record is created. One Yogesh Kumar, such and such, mobile number such and such, has produced one Ram Singh, son of their such and such, Bihar, before this court, under arrest in connection with CR case number 6 of 1996, arising out of CR case number 413 of 1994, on the strength of transit remand order dated 26/9/2022, passed by learned CJM, Buxar, Bihar.
Why this order was passed? CJM.
Order, my lord, this order. This order, the transit demand order, my lord, we do not have. Also see.
Now Bihar court must issue the transit remand. He must be arrested on the basis of some order, some warrant. Where is that warrant?
My lord, here it is
If
said-
you have created this record on 28/9/2022, and what was the occasion? Occasion was his production on the basis of one transit remand on 26/9/2022. Transit remand is issued by Bihar court by request of somebody, on the basis of some order by the court trying it. Those are not available, which reflects from 28/9/2022 itself.
Thereafter it said that since seeing the application and considering all the attending facts and having considered the nature of offense, as he is demanded to disclose after the case. Even though the original case record should not be fetched out immediately pending search and searching of the record, Acting Jansi be remanded to judicial custody till 12/10/2022. Thereafter, time again kept on reactivating. Finally, my lord, we have also enforced in order that.
Any LCR recording, sir? This is not done. This is the file created on the said date, well, then, prior to that, nothing is there. Yes, madam, how will we assure that you can be, you will remain present before the court?
I'm not any condition or not to do it. My
Only
lord, I on instruction, I'm saying, I know they are ready to permit our global service. Landed for.
local surety.
There is no prayer made by the petitioner for until they have come for talking with the entire proceeding.
This is a application number 482. Will grant bail under 482. We have that power.
So maybe there are some they can come under those. See how we can have those also done by somebody. That's exactly this is how this is.
Tell us, see the situation. The mighty CBI has not been able to reconstruct a file for 1 year.
And there's an inquiry of it, but then nothing is done.
Nothing is done. Record starts from his production. Even we are not aware when that warrant was issued, how the production warrant was issued by the magistrate. Nothing is.
There are dates.
What is your prayer in this petition?
There is something to portion express.
And not there is another prayer where you also can invoke the ignorance. That is. For the pass the world.
That's correct, but this also you have also committed a mistake.
My lord, because here we had come up, my lord. I
Your
have-
only prayer is to expedite. We'll say you construct the file within a period of 15 days and consider his bail application in view. Will give some observation and file and bail
My lord,
application.
we had prayed for washing also. My lord,
Quashing is difficult.
because, my lord, in that.
Quashing is
period-
difficult. Quashing on delay is difficult in this case. Such huge quantity.
My lord, by invoking the inherent jurisdiction, your lordship can. My lord, because I tell your
Show
lordship,
us a judgment.
my lord, we can file an.
Let us do one thing. We'll give you a deadline. In the meantime, we give some observation that what we are feeling. That for the fault of this, a person cannot be put behind bar. And the observation, and accordingly we'll ask her to file an application for bail. Not I file a bail before the court. Court will consider taking note of the observation made by us. That is the option.
My lord, may we find it here, my lord. My lord, again, we'll say the same thing, because many a times such prayer was.
Okay. You file an application along with this.
Buying this.
No, not IA. You file an application for bail 439. We'll list along with this.
That's right. Any day continue to lordship and it is Friday, my lord.
You file, then make a mention. We'll list it.
Friday.
We'll pass an order here today. Not today. We'll upload it on Monday. We'll go through this record. This is, we are not happy at all.
And
A
also,
person cannot be put behind bar like this. But problem is that 482. Of course, there is some, in some judgment, Supreme Court has says, don't exercise grant bail. That is
yes,
where,
that is the reason
that-
why, my lord, I also.
That may not be proper corner part, but this court view is that it is not fair on this person. He may be criminal whatsoever, but you cannot put a person behind bar like almost for a year on the pretext that we will prepare the record. And how many witnesses? 51. You file an 439 applications. So, okay, we'll pass an order and fix this matter on. A long matter is difficult. It's,
But it will take short time. It's already at the thumbnail of your lordship by now.
22nd.
20 seconds. My lordship, 20 seconds.
I think 15.
Ask your CBI to do expeditiously because you are having the case diary. If you are having your case diary, you can do, you'll have to reconstruct a search sheet. Search sheet is not there.
Because of the law, it was stolen. One country, initially it was stolen. Therefore, on the basis of the photocopies of all the.
But stolen is also not there. Have you lodged any FIR that this is stolen? Huh?
No, no,
So you proceed on that.
not that far.
Any accused,
Not to be a not a matter. And it was stolen. It is
but that will not.
only the case account, his personal belongings were also stolen. And the mistake was stolen to the train of it. Therefore, he was in a file of it. Therefore, not on the basis of 35.
It is stolen, not stolen. Who knows?
I am
Where
making my submission on the basis of
record, that's correct. But this is not the way.
But
Yes,
same-
had it been okay, yes, we are doing, this is the record. Within a month or 2 months, this is the record we are proceeding. That would be different. Days after this 1 year has gone, you have not reconstructed the record. And he is behind bar and how many witnesses? 51. When it will start and when will it be concluded trial? Will you even find those witnesses? Some might have been enjoying somewhere else.
But they will be more
That is somewhere else upstairs. Yes,
much obliged, your lordship. My lord, we shall file and provide the number to your lordship.
you make a mention, you can make a mention, but I do not know whether that matter will come before this court.
My lord, my diary says like that.
No, that we cannot, because as per roster, special is something different. To make a mention if it is listed somewhere else, that this matter is being,
My lord, only one thing, my lord, let this be treated as a part of it.
it is a part of hard at some level.
Not so easy.
I think 15.
Much so like.
15. Revision. Yes, yes. What is this? What this matter is about? Okay, let him file an affidavit. Okay. You are Mr. M. Borman, learned counsel submits that he has entered appearance on behalf of the sole respondent. Sole respondent, and he needs some time to file an affidavit. So prayer is allowed. List. After list on. Give a date. Huh? 15th. 16th of October. Don't press for any interim today. Okay, the registry to show name of Mr. R.P. Singh as the counsel for the petitioner in the cross list. One six.
I think 65 of supplementary list.
Mhm.
I have got some difficulties. I'm gonna take care of this. Accordingly, I sent messages to that line to WhatsApp. And I told that shows, there is it shows that we already use it. On 23rd February, and again yesterday, I specifically make a maximum of the WhatsApp message. So I'm not going to get it with you. Can we agree with that? So that's why I want to stay on my path with you.
Okay. Hard.
And that part will also continue.
Heard Mr. S. Sahu, Learned Counsel for the petitioner. Appellant. There is some other lawyers name is also shown. What to do then?
You're my team, madam. You're darling.
Your junior.
Yes, not junior, madam, but you're my associate. You're darling, and others are. Only J. Dalam is there. Of same chamber.
Your name is in the Wakalatama, so that we can record it. Mr. S.P. Bhattacharya, Learned Counsel for the respondent, submits that we have some personal difficulty. He was having some personal difficulty in appearing this matter. Accordingly, he intimated the respondent number 2 regarding such difficulty and requested the respondent number 2 to engage a lawyer. And engage a lawyer, full stop. He also sent WhatsApp messages, and according to him, such messages were duly delivered. However, no counsel has been engaged. Full stop. The present appeal under section 378, present appeal under Swensu is filed against an order dated 9/11/2018, passed in CR case number 4052/2017 by the Learned Additional Chief Judicial Magistrate, Kamrup Metro. Full stop. By the aforesaid order, where is that order? By the aforesaid order, the CR case, by the aforesaid order, the complaint case being CR case number 4052/17 filed by the present appellant under section 138 of the NI Act was dismissed for non-prosecution on the ground that the complainant was absent earlier on 11/10/2018 and on 11/10/2018 and on the passing of the and the date of dismissal, that is on 9/11/2018. Accordingly, the respondent number 2 was acquitted. The Learned Counsel for the petitioner, appellant, submits that the default was, where is the grounds? Okay. It was, where is the, which paragraph? Mr. Sahu, you must be ready with that. I told you yesterday that I will allow this application. Paragraph. It is submitted by Mr. Sahu. Record is there. Huh? The record reveals that on the matter, when the matter was fixed on 13/8/2018 for cross of PWs, not PWs, CWs, complainants witness, CWs. Cross of PWs, isn't it? Cross of PWs. The complainant as PW could not come before the learned court below on that day, and his counsel took steps by filing an adjournment petition, and accordingly the adjournment was granted, fixing the matter on 11/10/2018 for cross of PWs. It is specifically pleaded that although the case was adjourned till 11/10/2018, the engaged counsel inadvertently recorded the date of the case in his diary as 10/11/2018 instead of 11/10/2018. Accordingly, when the matter was fixed on 10/11/2000, accordingly, when the matter was listed of 11/10/2018, it was unrepresented and the counsel was not aware of such fact. However, as the case was recorded to be fixed in the diary of the learned counsel on 10/11/2018, on that day, when the counsel went to attend the court, he came to learn that matter was already dismissed for default on 11/10/2018, acquitting the 9/11/2018 by the learned court below. Learned court below. Considering the nature of acquittal and the fact that the fault was not on the part of the complainant, appellant, this court is of the view that the present appeal be allowed and a chance be given to the appellant to contest the matter CR case number so and so on merit. Accordingly, the order dated so and so stands set aside and the matter is remanded back to the learned court below for a fresh trial from the stage when it was dismissed. Subject to payment of a cost of rupees 10,000. What is the amount of the check? Subject to payment of a cost of rupees 5,000 to be deposited before the learned trial court and be paid to the accuser. Don't argue anything. We'll say no, dismiss it. 5,000. We'll just modify some. We'll give some judgments and elaborate it. additional, we'll see, we'll correct. Hello, if you know that.
For hearing item number 60, what are matter?
Two o'clock. At 2 o'clock, there are too many methods. Anyway, okay. No. F2,
61.
yes.
Can we see that it is RT 2019? So correct. The revision is admitted for hearing subject to payment of 60% after compensation due because of that in a period of 6 weeks from today. But it is still now, they have not deposited.
Okay, what is the impugn order? Impugn order is it? Record is there. Ah, the present none appears for the petitioner on call. Full stop. However, you are Mr. N.B. Sharma, learned counsel for the respondent is present. Full stop. The full stop. The matter, the present revision petition, criminal revision petition is filed assailing an order assailing judgment and order dated 11/7/2019 passed in criminal appeal number 224/2016 by the learned additional district and session judge number 1 Kamrup Metro at Guwahati, whereby the judgment and order dated 13/7/2016 passed in CR case number 2 of 2013 by the learned judicial magistrate first class convicted the present appellant under section 138 of Negotiable Instrument Act 1881 and sentence him to undergo simple imprisonment of 6 months for offense under section 138 of the Negotiable Instrument Act, and further directed to pay a compensation of rupees 11 lakhs only, and in default to further undergo simple imprisonment of 4 months. Full stop. This court, where is that order?
Order says 30/10/2010.
30/10.
10/2010.
This court admitted the present revision petition this court issued admitted this present revision petition for hearing, subject to payment of 50% of the compensation amount before the trial court within a period of 6 weeks from 30/10/2010, with a further direction with a further direction that the respondent can withdraw the same on due identification. Full stop. What about 50%?
And we need to pay 8 lakhs. To the responding individual in 6 months.
From today,
In September.
if you can pay within 6 days, we can adjourn it. We are not happy with your conduct. We are dismissing your petition. Have your instruction at 2, whether you can pay within 6 days, otherwise we are dismissing. We are not exercising our power under 482. We are dismissing it. উপরে দিব উপরে দিব heart. You are Mr. Huh? Give your name. Actually, it will continue to dictate it. Yes. Series there. Where is the affair? What is your name? Anam Khan.
Anam Khan.
Your friends are arrested.
By the
Khairul arrested,
And
Aminul arrested, Anam could not be arrested.
arrested. He is the main person who given the blow to the police person.
Why? What is the reason?
Well, they were expecting at 1 a.m.
Okay.
When the police party got there, asked why you are in here at 1 p.m.
Hmm.
Didn't matter. Medical issue also there, matter. Problem simple matter, but the police person basically.
Your friend has detail how the incident happened. Rejected. If you know, the material available on record, including the statement of the co-accused as well as the witnesses
And medical issue.
and medical reports, corroborates the allegation level in the affair, in as much as it is seen from the record. The present petitioner is the present petitioner was the main person was the main person in assaulting the police personnel. Accordingly, this court is of the view that this is not a fit case for a grant of anticipatory bail. Accordingly, the same stands rejected. How many methods are left? 5, 6, 9 methods left. We will first take up the bail methods. If somebody comes, then we will go to the
Except two items, item 17,
yes,
It's a case with
charge sheet. Being charge sheet number
78 of the 11,
78/11,
31/8.
dated 30/8/2000. Okay, so accordingly, go to the BA, apply for application, regular application. When the event such application is filed, which tribal by? Tribal by
And where my is the
session. Before a trial code, just like the trial code, because it's a 439. 438 only, then it will come, question will come interim. It's a 439.
item 32,
Yes,
This case also is certificate. Case number 214 of this 26, dated 26/8.
sessions or magistrate,
Whether it is whether the second.
sessions tribal, till committal is application and file an application, trial code. So interim will continue. That is what after committal till appearance before the trial court. We are saying trial court.
37,
Next.
Yes.
It is 238, the application number 2 it's in the
FIR is on.
page 15.
Who are you?
Petitioner one is the also president of the town of that, and that's the petitioner number 2 is the husband of it.
GP president,
Yes.
petitioner number 1 of Pabho Gaupon, sir. Okay, and petitioner number 2 is
husband. It's a constitution in Nepal of this country.
his husband. Husband and wife both are members.
Actually, wife is the president and right. No specific allegation was nominated.
Not necessary. Yes, what is the case that?
After entering the statement recorded. There is for
Forget about statement. Gao president, secretaries, misappropriation, forget about statement.
government.
Government fund.
There are 5 projects are there, madam.
What is their involvement in terms of the case that? We are very strict so far relating to people's representative.
Carry out the government will also be arrested for this.
What is his statement? Can secretary do something without approval of the GP?
Here we also prepared with the university one. The state of the state.
Which place?
Who was there from Viewpoint, Viewpoint.
Not only you. One is blaming other is blaming
Right.
other. Hmm.
They said that they are earlier, and earlier also said. They are already active logic, because they do the fiction, there is a trial logic in classic logic. It will be protected. If they have covered logic, consider they will face logic there. If they have logic,
Let them face their consequence right now.
if they are cooperating logic, not granting any of the condition logic, let the student of their logic will continue to work.
A, a detailed investigation was done. Here is the case diary, which reflects that detailed investigation was done. And the same reflects misappropriation of government fund against different projects sanctioned for public purpose like community hall, gymnasium for people, etc. Hall, gymnasium, volleyball field, sanitary latrine, and community hall, wherein the husband of the Gao Panchayat president, who is also a petitioner in this petition, was the chairman of the said committee. Considering the nature of allegation and misappropriation of public fund, this court is of the view that this is not a fit case where the petitioners are entitled for privilege of free arrest bail. Accordingly, the the bail application stands rejected. Interim order passed earlier stands vacated. Case diary will
41.
yes. Cities there.
It is there. It is. He reflects like he has appeared, but he is also entangled with the sorry from
But don't say that, use the word smuggling. Don't use the word smuggling.
by illegally active because it was produced by illegal. So whether and this has been going on, madam, and that's not the first time, madam. That's why we have to, we used to bring on the rest of one another two issues. In turn, madam, we used to receive 5,000 rupees.
Considering the nature of allegation against the petitioner and also fact that he has cooperated with the investigating authority after he was protected by this court. Cooperated everything, no? Absolutely.
I don't think that there is something. I okay.
46.
Appearance nowadays, oh, this is JCB accident.
People have seen that.
Accident.
While overtaking the JCB lorry, it has collided the JCB and he fell down.
Absolutely.
47.
But these JCBs are not, should not be allowed.
Have drive very harshly.
No, number one is, that is one aspect. Other aspect is these JCBs are not to be driven in the road in the daytime. They cannot move their,
They would see also.
they could not see. That is the main reason why so many accident of JCB. Yes. Hmm. Phase.
My company is working with an India, that is a big bank and Guwahati. It is to the three to the notice that one of our staff is registered. So on the series, registered the residents of Toronto, apartment, Kalibar, Guwahati, as per the report, within Malani for services. Is working with us as a account executive has been done since the last 6 years and looking after the work of the for finance, account, payment, between say petrol pump payment and maintaining all related documentation. Mr. Jaideep Thakur was transferred to our Goripur branch in the month of March 2023. He has been asked to report the activities for closing the financial year 22-23. But following anomalies has been found. Number one, there is a dispute in payment of petrol pump and basically by the approximate amount is 20 lakhs. He has provided the manipulative NOC soft copy partner. Management of fund has provided the original NOC is different amount. During the during the bank reconciliation 2523, it is found that he has used for not the whole state of India. Then his whole IFC code of this period 714 for Institute of the Company Fund, which has been transferred to distributed by Indian Bank. Dr. Guwahati, it is assumed that the amount has been transferred to close them. This is my love.
Yes, what is your case?
Now, my love, for a moment, my love, regarding that, my love, there is a two elevators. One is the of money, my love, payment, regarding payment. Before that, my love, I want to show one that, my love.
Hmm.
And you looking to the page 11, my love. My identity card.
Yes.
My designator is coordinator, my love.
Hmm.
Financial case, my love.
Hmm.
Yeah, my lord, this is payment, my lord. And regarding this kind of first elevation, my lord, there are three offices in the Guwahati, my lord. One is regional office, one is administrative office, and one is my lord, field office.
Hmm.
Field office in Baihata, my lord. Administrative and regional office in Guwahati, my lord.
Hmm.
Here is the case, my lord. They say that I have manipulated that, my lord, the soft copy of the bill, my lord. The bill sent from my lord Baihata, my lord. I, as a coordinator, my duty to forward to the account section, my lord. If anything wrong is here, my lord, then my lord, the manager is the role for that, my lord. They have not filed any FR against the manager. my lord.
What are the said?
Regarding check is also, my lord, that I have issues for all check, my lord. Kindly look into my lord, there is a 2 person, my lord, authorized to sign the company check. I have managed the sub check, my lord, page 19, my lord, for no number. I am the not authorized to issue the check, my lord. Page 19, my lord. One is my lord, accountant, and another is a manager. Both signature is required. This is the company check, my lord. I have NXT company check, my lord. How it can be, my lord?
Yes, what is the case there?
If there, my lord, there are only one witness.
Hmm.
This was also a traffic supervisor.
Hmm.
And the complainant is himself. And on the traffic, complainant have stated as per,
Right.
he has stated traffic supervisor. তেওঁ টকাৰ খেলিমেলি কৰিছে লগতে হিচাপ নিকাচ দিব পাৰা ভালকে দিব পাৰা নাই আৰু সেই তেওঁ
Has he recorded his statement?
no, he is not in the
There.
and the police is
I am
touching him.
ready, my lord.
And he has kept his mobile phone switch off. So that as their CDR is cannot be recorded.
My lord,
I have his mobile is switched off.
my lord, why they lost the Qatar, my lord?
Yes.
I am giving up. Here is a disagreement about my transfer, my lord. In a meeting, my lord, I have some private dispute with the regional manager, regional manager. So regional said, I will see you, but I refuse to go in the join in the new place, my lord. This is the main thing, my lord. I am ready to provide any condition, my lord, whatever, my lord. Two allegation against me. my
What
lord.
is the statement of this petrol pump owner?
The petrol pump owner, my lord, I don't know, my lord.
Only the complainant and one witness. And nobody is witnessing something.
But this is necessary. This is 20 lakhs to a pump
CD will be updated.
updated.
Updated because.
We are giving him a protection. Let him appear, get the statement recorded, and you give the updated CD. Then we'll see. Okay. Perusal of the case diary reveals that the investigation is at very early stage. the learned additional public prosecutor also submits that for the purpose of determination of present application, updated CD shall be prepared. Full stop. Considering the above, the matter said adjourned and CD is returned back for updation. Full stop. In the meantime, it is provided that the petitioner shall appear before the IO to record his statement and furnish any material to the IO in his defense. Full stop. Petitioner shall appear before the IO within a period of 10 days from today. Full stop. Let the matter be listed on
On 29th of December, leave the.
the 29th of
Ten,
10/10/2023. Full stop. Till such date as an interim measure, it is provided that in the event so appear within 10 days, it shall not leave the jurisdiction of the IO without permission from the investigating officer. List accordingly. Let the investigation be proper. Yes, where is the application? This is an interim order. Yes, 50 is the interim order. Heard. The land council for the petitioner. Also heard the land additional public prosecutor. The petitioner is an accused in connection with accused in police station number. Huh? Accused in PPS, which police station? Tokwar Khana PS case number 281 /2020/21 corresponding to PRC case number 63 of 2022. Full stop. The petitioner approached this court during the investigation by filing an application under section 438 apprehending arrest. Accordingly, this court under its order dated 5/1/2022 passed in AB 6/2022 granted interim protection to the petitioner. Before the matter bail application was finally decided, search sheet was filed. Accordingly, this court under its order dated 31/3/2022 passed dispose of the aforesaid bail application, providing that interim order passed earlier on 5/1/2022 shall continue till appearance of the petitioner before the learned court below within a specified period. Full stop. Subsequently, yes, no, the other order by this court. Subsequently, and non-bailable warrant of arrest was issued by the learned SDGM Dhokua Lakhimpur in the PRC case number 63 of 2022 against the petitioner by an order dated 18/3/2022. The said order was assailed by the petitioner by the petitioner in criminal petition /365/2023, and this court under its order dated 25/4/2023 directed that said petition was disposed of with a direction that petitioner will appear before the court on before the learned SDGM on 3/5 before the court of learned SDGM on 3/5/2023, and on his appearance the non-bailable warrant of arrest issued on 3/5/2023 shall be recalled. Full stop. It is stated that the petitioner could not appear on 18/3/2023 due to illness, and accordingly, again on 17/6/2023, however, such prayer of the petitioner was rejected, and against non-bailable warrant of arrest was issued. Full stop. Considering the matter in entirety, including the fact that in the meantime, search sheet has been filed and the petitioner was granted interim bail during the investigation, and the NBWA issued earlier was also recalled by this court. It is provided that the petitioner shall appear before the learned SDGM within bracket M and on his appearance, the petitioner shall be allowed to go on bail of rupees and the NBWA with the following conditions: we will appear on every basis before a file and the NBWA issued against the petitioner is hereby recalled. What's your
66.
Yes, Manjur Ali. Anything? Okay. Any report? X. Pursuant to order dated 20 it ought to have been 19. Pursuant to order dated 19/2023. Are casual. Heard Mr. H.R.S. Chaudhary, Learned Counsel for the petitioner, assisted by I.R. Deka, Learned Counsel for a petitioner, also heard Mr. Borua, Learned Additional Public Prosecutor for the state of Assam. The present application is filed under Swenso. Peruse the material available on record. Full stop. Peruse the material available, which discloses that during the period of custody since 31st 2022, the petitioner uh, fell ill and was admitted in Dhubri Civil Hospital, and thereafter, for better treatment, he was sent to Guwahati Medical College, wherein he was admitted for almost a month, and thereafter he was again returned back to the custody in jail. However, again the petitioner fell ill and in fact fell down in the court premises when he was presented. The record also reveals that the petitioner could not be presented from the jail hazard during the period of trial due to his illness. Subsequently, again he was admitted at civil hospital Dhubri. However, after some treatment, he was put back to the jail hazard. Full stop. Mr. Chaudhary, learned counsel for the petitioner, submits that the petitioner has seriously been ill and his family member wants to treat him in a better, to treat him in a private hospital so that better treatment is given. So therefore, he may be granted bail on this held ground for a period of at least 2 months for better treatment in a private hospital. Full stop. Consider the material available on record, including the report of the senior medical and health officer, officer 1, district jail Dhubri. Full stop. Mr. Borua has also obtained telephonic instruction from the jail superintendent, which also discloses that the petitioner was not keeping well. We'll say that much only. In view of the aforesaid and in the totality of the matter, this court is of the view that the petitioner will have a right of a better treatment in a private hospital in the given facts of the present case. Accordingly, it is provided that the petitioner shall be released on bail for a period of 2 months from today given date. That is still 2 months till November 10th. November 10th on furnishing of so and so. After completion of the aforesaid, during that period, petitioner shall be at liberty to get treated himself in a better hospital in the state of Assam. Full stop. As an interim measure. In so and so to the satisfaction of additional session judge Bilasipara as an interim measure. List this matter on 10th of November 2023. We have given an interim measure. We'll see what is the situation. We'll see. No.
For hearing, I think 60.
Last November. No, we are hearing a matter, no? No. What I'm hearing dictation on the voice. Yes, so what about the negotiable instrument case? We are just in the midst of a hearing, Mr. Sharma. Just wait for a minute. 61. Yes, what is your instruction? 15 days, we are after 15 days, we are fixing a date and we will hear this matter. Full stop. The present appeal, against so and so. the appeal was admitted on Tuesday. However, the aforesaid amount has not yet been deposited. Accordingly, this court proceeded on hearing the matter. However, the learned counsel for the petitioner submits that he is willing, his client is willing to pay the 50%, deposit the 50% amount within a period of 15 days from today. Accordingly, he seeks an adjournment. Full stop. Considering such submission, the matter stands adjourned and will be listed on 16th date from today. Now September 2023. In the meantime, the petitioner, as assured, shall deposit the 50% of the compensation amount before the learned trial court below, and in the event such deposit is made, the respondent complainant shall be at liberty to withdraw the same, subject to proper verification and identification. List accordingly. Yes, Mr. Sharma. He is raising a question of maintainability. Your ground is that that question was raised earlier. Court has taken a decision in your favor and remanded the matter back. And therefore, this issue no more can be raised. This is your case. Mm. Okay.
Without the hearing,
Mm.
more so.
Mm.
In the 2007, the Supreme Court
Mm.
has decided
Mm.
in this respect, all India government and court,
Mm.
all India governments
Mm.
in the Union of India stations, the judiciary has been separated.
Mm.
Judiciary has been separated in respect of the secret, in respect of the fixed tribunal.
Mm.
That in this respect, that the judiciary is also separated in the Mahasabha.
Mm. No, I think he has concluded his argument.
No, I appeal live before a district council.
Ah.
Now, this is not the forum where
According to him, appeal lies to the district council forum.
district council court is not a court at all, my lord.
Hmm.
We never get the justice in that district council or, and as well as the other councils. As because there is, they have not obeyed your other high court order.
Where is the earlier judgment?
I don't know, my lord. Thank you.
No, judgment by
After the review,
there is a review also. That is, review is 122. An earlier order by my Lord Justice Goswami and Justice Chaudhary. Is that it? No, I want that judgment. Where court says that exercise of jurisdiction was not proper, therefore matter was remanded back. Then review was filed.
You get file challenging the jurisdiction, customary court. And in individual court, the subordinate district council is the only court.
Which paragraph you have quoted?
I have quoted in the review.
Okay, paragraph 4. No, the original order prior to review, the original order. I think that is next year somewhere.
Page 26, page 30. Of their appeal.
Page 30.
That time this issue was not there. That is really good.
Who filed a review?
You filed by them.
Why review was filed?
Their purpose was to say that council court has no jurisdiction. That was the point they want to
Raised.
raise in the appeal. They cannot raise that.
Hmm.
So they filed review saying that customary court of Assam has no jurisdiction.
Hmm.
Then court narrated the entire fact.
Hmm.
And in paragraph 18 of review petition, what you will see,
Hmm.
court has confirmed that subordinate district council court,
Paragraph?
paragraph 18 of the review.
Hmm.
In the light of the above discussion, it is established that subordinate district council court has not been divested of its original jurisdiction in any manner from conducting the trial of suits and cases between the parties, all of whom belong to civil tribe within its territorial jurisdiction. As a corollary, in charge of court of just subordinate, not Kasar Hills Autonomous County, is vested with the jurisdiction to try the divorce proceeding between the review petitioner, that is Dearham, and the respondent, both of whom belong to the civil tribe and are resident within the territorial jurisdiction of the state court, to the exclusion of any other court in the North Kasar Hill district. In view of the Hills Court does
Who
not
filed a
find-
divorce petition? Who filed the divorce petition?
Petition filed by the respondent.
Husband. He filed in the customary court.
Yes,
And customary court's decision according to you should be challenged in the council's court,
district council.
district council's
Under
court.
rule 13.
And so therefore, according to you, this matter should go back to the
Yes.
customary court. According to Mr. Sharma, in view of separation of judiciary from the executive, from separation from of the judiciary from the executive, it is the civil court, and therefore the appeal to the high court is maintainable.
Yes.
Because there is a separation of judiciary. In All India Judges case, it was said that there should be separation, and in the case of Registrar General, Guwahati High Court, the separation was made. This is the issue.
That was the full court has been decided.
Hmm.
Full court has been decided.
Hmm.
The High Court.
This High Court, that is Registrar General's case.
Registrar General case, my lord, 2000.
You will argue in Registrar General case, though separation is there, there are two parallel lines. A person may opt either for the customary court or the regular court. If it opts for regular court, it will go by that line. If it opts for customary, it will go by the customary line. Since they have since you have opted for customary, they participated, it will go by the customary. They have never raised the jurisdiction at the initial stage, and which was raised at the review stage, it was also negated. This is your case?
Then paragraph 30 of their Registrar General case, my lord.
Ah.
I have quoted. May I read it, my lord?
Yes.
We further hold that CPC and CRPC are applicable to the regularly constituted civil and criminal court
Hmm.
without in any manner affecting operation of Article the functioning of customary or any other code
Hmm.
other than regularly constituted civil and criminal code in the state of twenty.
Hmm.
At the same time, we have protected and this.
So here first issue is the maintainability. If it is maintainable, we'll go further on the merit. If it is not maintainable, matter ends there. So we'll first decide the issue of maintainability. That is. So am I correct? Your argument is that see, there is no scope for the customary court to continue because there is a separation of judiciary. Now the CPC, CRPC are applicable. Judiciary has been separated. Earlier it was the deputy commissioner, council, etc. Now it is the district judge, civil judge, etc. Therefore, there is a separation of judiciary, and in that view of the matter, appeal will lie before this court. This is your argument, and he,
As argued, honorable Supreme Court system,
yes,
it has been done.
yes.
The separation has been made.
Separation has been done in the judge's case, and in that subsequently by the Registrar General's case in our. And his contention is that all these cases, nowhere customary courts are disbanded. Only two parallel lines are created. One is customary, other is general court. Whoever opts for which court will depend upon facts and of the each case. Okay, hearing concluded, judgment reserved. On maintainability.
One might argue something.
Yes.
Their contention is only in the customary administration of justice,
Yes.
not for judiciary.
Yes.
Administration of justice, not for the judiciary.
Hmm.
Not for the judiciary.
Hmm.
I humble and respectful submission, the plural of CCP,
Hmm.
that nobody can take data for his own wrong.
Hmm.
And appeal is a judicial activity.
Hmm.
It is an inherent power.
Appeal is filed under what provision?
Appeal is under 40. Therefore, why not? No provision.
Huh?
No, appeal. Memorandum of appeal.
Huh.
It is the memorandum under 41 million. No.
Order 41. Since though no mentions according to decision order 41.
It is for pension.
Huh.
Though it was for pension, it is an appeal.
Hmm.
No presumption can be taken. It is matrimonial appeal has also. It is
Been registered.
matrimonial appeal. And my lord, I humble and respectful that is very violent file for not to be the honorable court. Your honorable court is
Earlier judgment says that spirit of this to be applied, evidence, reasons to be given. So therefore, they have not done that.
no, that is not done in the my lord. Amnesty order.
You take your seat, we've heard you. We'll hear Mr. Sharma. Yes.
That is my lord. Come to this point of this. My appeal.
Yes.
They were at this 16.
1-6, yes.
It is that appeal which has been filed in accordance with the order, judgment and order of the Honorable High Court.
Hmm.
Began justice of the. My lord, the Swami and
Mr. Chaudhary.
It is therefore that Your Honor would be pleased to admit this petition or for the 11 records and after hearing the parties.
Yes.
After hearing the parties, further be pleased to pass an order directing the marriage, declaring the marriage between the parties, the whole state and non-marriage. But there was no hearing, no conciliation, no issue. Well, I have also, as part of our good that we have filed the written statement. That written statement is also not considered. I went there I quit. I'm a child. Hearing anything. No, no, no. No hearing, no hearing. No hearing, no hearing. In this way, says, where there is justice? Where is the justice in this, in that court? Justice must not only be done, but must also appear to have done. And it will be here, if that will be allowed, then it is the malice in law, my lord. The malice in law. It is a legal malice. And it will be affecting the judiciary. They have long obeyed the Honorable High Court, Sardar. They have not taken any evidence, no issue. I know any legal statement has been going through. Allowed. In earlier case, alimony has been for 4 lakhs, and next case, alimony has been 7 lakhs in their own money.
Alimony also may not be told.
No, my lord, that is, I have not yet. It is the position and tenant in the pollution with those persons. In pollution with them. They have not obeyed the Honorable High Court. Let me organize the issue. It's a little, my lord.
That is, not when it's not standardizing the court order without saying any ground. And earlier also, Madam Sadhya, he has filed a review petition, challenge the jurisdiction. Now on
Now-
that matter, this committee,
I explain what submitted
without finding any.
he is admitted to criminal case.
What my
He is admitted to criminal case. That he has been admitted to criminal case, he has been admitted to that case is in their favor. Only for that reason he has been admitted.
All these things are already considered in review petition.
No, that is not my,
Yes, all these things are considered.
Okay.
your, my lord, if you are not to that. That means there one criminal case for 98 against him. That is respondent. And criminal.
What happened to that?
That is additional crime, I am the accused. They have filed a falsely filed 20 case, I will judgment matter.
It is in their favor. That is, they are negative. Criminal is admitted. As it was, although it was in separate in judicial, under the judicial. But in this case, they have been not admitted. What is the reason behind? What is the reason behind it? They can manage. They can manage the council court. Only for that reason.
Suppose what is the remedy beyond council's court? Suppose assuming for a moment, Mr. Burua, what suppose council courts goes in his favor, what will be your remedy?
The council court, after subordinate district council, I will go for appeal,
Appeal before whom?
district council court.
No, suppose you are saying that the decree made in your favor by the subordinate judge, the appeal lies to the district council court. So therefore, this court is having no power. This is your case. Mr. Sharma's case is that this court will have power because there is already separation of judiciary. Isn't it, Mr. Sharma? Yes. Now just another query. What is this district council courts?
Some high court jurisdiction over district.
No, that just suppose a order is passed by district council court. Is there any further appeal be?
Under that, I have placed the book, my lord,
Uh.
order 3 kindly see.
Assam High Court jurisdiction over district.
An
council-
appeal against the final order of decision of district council court in civil suit where valuation shall lie to the high court.
That is the.
Okay, therefore it will be Hill's appeal.
Yeah,
That
that is yet to come, that stage. Before that, he is arguing the case. Yeah.
But his case is for, these are not applicable as on date. Isn't it? Now it is, it's, even if his case is that even if it is there, the direction issued by the division bench in the first round of litigation has been flouted by the subordinate court, isn't it?
Yes, sir.
Flouted. This is his another argument.
Yes, sir, that is argument without basis.
What are you doing?
I-
Is there
I-
any- is there any evidence? Is there any evidence?
There is nothing in.
All for the record, my lord.
Yes,
I shall give up my the advocacy.
yes.
All for the record, my lord. Whether there is an evidence in their table.
No evidence. So we'll first answer the maintainability.
Yes.
If we say maintainable, then we'll go on merit.
Yeah.
And go on merit.
If take my brief note I said,
Huh.
if you consider come to case 3,
Mm,
rule 21, number.
mm,
Yes, the rule 21. That is under the North Coastal Hill Autonomous District Administration Justice in 1955. Rule 21 says subordinate district council court shall have original jurisdiction in all suits and cases in which both the parties do not fall within the local jurisdiction same village, but within the areas under the jurisdiction of the subordinate district council court. And also in cases and suits referred to by the village court. Now, my lord, rule 22, the subordinate district council court shall be competent to try all suits and cases in which both the parties belong to a sitting tribe or tribe resident within the jurisdiction of the subordinate district council court other than two cases referred in rule 20. Now, next step, you have a rule 30 or rule 3. These are the all things and just rule 47 may I just, my lord?
This is volume is 11, no?
Here, another volume 1. madam. Here, volume 1, you will also find administration justice.
Volume 1. Are you having this book?
Yes, I have.
Are you having this book? Local action rules. Huh? Volume 1 and volume 11 call.
Volume 1 is there. madam. That is-
Okay, we'll pass this order. Mr. Samay, you want to add something? Yes.
Administration of justice in the administration and the judicial justice.
Different. According to you, when it is the justice in administration, then this rule will be applicable. When it is in justice in judicial forum, it will not be applicable. Okay.
Also, or the act of the meaning something like that.
Mm.
That is the administration of justice.
Yeah.
It is not a judicial justice.
Not judicial justice. This relates to administrative act,
Yes, ma'am. It is an administration.
not a judicial act. This is applicable to an administrative act, not to a judicial act. Yes.
And my humble understanding is in all India justice cases.
Mm.
That is also already been judicial. And this honorable title.
Mm.
Under section 5.
Mm.
And also section 4.
Mm.
141 is the finding. And the article finding, that is when the Supreme Court has been.
Supreme Court's constitutional power under 141 and 42 becomes law and binding upon all over India.
All right. This is my.
Do you have the copy of the All India Judges?
I will refer to the jurisdiction para 7. All these are considered. all in the justice.
No, my lord, that is not.
Para 7 only.
That is, that is.
Where is so worried? Mr. Sharma is arguing, take your seat.
That was the this submission earlier.
That is my lord. My lord, only your lordship looked up the.
He has raised a preliminary objection. We will answer it. If answer goes in your favor, we will enter into the merit. If answer is goes against him, we will not answer it the merit. But since he has raised, we are bound to answer it. Is that it?
I am going to I'm not.
Just give me a minute. Your first argument is that this rule shall not be applicable in view of separation of judiciary and executive. And separation of judiciary and executive is based on the principle and law declared by Supreme Court in the first judge's case. First thing. Second thing is that this relates to administration, not to the judicial administration. General administration, not to the judicial administration. These two things. Therefore, an appeal will lie before this court.
And I also, and also another. If you is an inherent power of your
Yes.
there, if you,
Mm.
if injustice has been,
Mm.
can be injustice has been made by the country.
When it is palpably wrong, we can exercise our appellate jurisdiction.
That is,
Is not it?
if it is an, relatively wrong something,
Mm.
is come before your judges. And we have raised it. The public should not be suffered
Yes.
due to the judgment given by this direct file.
So according to you, trial court judgment cannot be said to be a judgment because the decision made earlier to follow the procedure has not been followed, no evidence taken, nothing of that sort. Therefore, even if no procedure is given in as this administration of justice rule, however, the spirit should be issued and spirit will meet in terms of the earlier judgment, the evidence ought to have been taken. This cannot be like a panchayat. Yes.
Not only about the cousins,
Qazi is-
cousins, so, hey, you don't do it,
Don't do it.
you get like that.
Okay.
And very much, annoyed about without on the high court order and doing and let both of the kids. Those parts that have been released into the part of the ability. And they are doing it by the same concept. The process of
Can you give the citation judge's case? Judge's case. Where is the reference, Mr.?
that is what WTC 1022.
Huh? WPC of 1980. Any citation?
No, you know, it's pending my life. It's pending this case. Going on my life.
Okay. All India Judges Association under the Union of India. WPC 10. Okay.
As per the 9/5/2007 and 10/5/2007,
Hmm.
I was.
Okay. Mr. Borua, have you given your note to Sharma Junior? Give a copy. Mr. Sharma, he has given a small written argument. You have it, and if you want to give a small reply or written note on your own, you can give it to my bench assistant. I will pass the order after a week. I'll make it. Huh? Tomorrow, day after tomorrow, Monday or Tuesday, you give your things and give a copy to Borua. We will dictate the order in between.
Okay. One copy here in my objection. The subsequent copy I
Okay,
will invite both because
okay. Hearing completed, the learned counsels and the learned counsel for the respondent has submitted his written note. Mr. B.N. Sharma, learned counsel for the petitioner, submits that he will be able to give a written note of argument by Tuesday next. Okay, Mr. Sharma? Tuesday next. First of, hearing concluded, judgment reserved.
Yeah, this kind of matter commission is accepted, then there will be very of court directly coming.
That you in your written note you give those. That Justice D.N. Chaudhary and Justice Borua, D.N. Borua's case and division bench.
This are also discussed in para 7 of the.
So list is over. You give by Tuesday?